Welcome to the Carnegie Council. Our speaker this morning is the Honorable Louise Arbour. The subject of her lecture will be the pursuit of self-determination, focusing particular attention on what is at stake in the upcoming referendum in Southern Sudan. I'm Joanne Myers, Director of Public Affairs Programs, and on behalf of the Carnegie Council, I'd like to thank you all for joining us. And a special thank you to Blair Blackwell and Josh Simulitz for their help in arranging this event. It is a great pleasure to be hosting one of the most distinguished members of the international community, the Honorable Louise Arbour. Ms. Arbour is currently President and CEO of the International Crisis Group. The ICG, as it is often referred to, is an independent, not-for-profit, non-governmental organization that is known for its commitment to promoting peaceful resolution to conflicts. It is also one of the best sources for information and reports on conflicts around the world. I know that there are many in the audience who are familiar with the extraordinary career of this eminent legal scholar and have followed her journey from law professor to judge to serving as a former chief prosecutor for the International Criminal Tribunal for the former Yugoslavia and Rwanda to UN High Commissioner for Human Rights. Still, for those of you who are less knowledgeable, I hope you'll take a moment to review her very impressive resume before she begins speaking about self-determination and conflict resolution from Kosovo to Sudan. The right of nations to self-determination is a principle recognized in international law and states that nations have the right to freely decide on their political status or form of government without outside interference. The principle does not state how the decision is to be made or what the outcome should be. Neither does it state what constitutes a nation. In fact, there are conflicting definitions and legal criteria for determining which groups may legitimately claim the right to self-determination, which has, in turn, led to an increase in the number of conflicts within states. The most recent example is Kosovo. In the mid-90s, Kosovo, a largely ethnic Albanian nation, sought independence on territories long held by ethnic Serbs. Conflict between the two culminated in the 1996-1999 Kosovo War. But when the war ended, the international negotiations to determine the final status of Kosovo were unsuccessful. In February 2008, the Kosovo Assembly voted unanimously for a unilateral declaration of independence from Serbia. Serbia rejected this, claiming Kosovo to be part of its territory. Nevertheless, on July 22nd of this year, the International Court of Justice, the UN's highest court, ruled that Kosovo's independence from Serbia was legal. The concern, of course, is that this ruling could strengthen aspirations for other ethnic minorities around the world in their quest for independence. While there are many ticking time bombs, the one that grabs our immediate attention is what is to take place in the Sudan when a referendum on the independence of Southern Sudan is held in January 2011. It is expected that Southern Sudan will vote to secede from the North, which will in turn raise intractable problems. The question is, what can be done to limit the potential for violence? Although the ability to direct parties in conflict is often limited, one can facilitate the process by proposing alternative methods of engagement towards peaceful resolution of conflict. Our speaker knows this so very well. Throughout her career, Louise Arbour has shown the world skilled leadership by her moral courage, tenacity, and her determination to seek peace through justice. In her position as head of the ICG, she continues to do just that. Please join me in giving a very warm welcome to our very distinguished guest today, the Honorable Louise Arbour. Thank you so much for coming. Thank you.
Thank you. Thank you very much. Thank you very much indeed, Joanne, and thank you to the Carnegie Council for Ethics in International Affairs for giving me an opportunity to speak to you today. I realize there are a few Canadians and maybe even native Quebecers in the room, and I'm sure they're very nervous to think that I'll be talking about a subject that has occupied and preoccupied so many of us for so long. But I'll tell all of them, just relax. I'll stay within the Kosovo to Sudan landscape so as not to make anybody too nervous. Since 1998, the International Crisis Group, of which I'm currently president since about a year ago, Crisis Group has supported the independence for Kosovo. Back then, 1998, which was, as you know, still at the height of the conflict between NATO and the Serb government, Crisis Group has taken the position that the Federal Republic of Yugoslavia had been unwilling to permit the free exercise of the Kosovo Albanians' right to self-determination, and that Kosovo was now entitled to create its own international status separate from the Federal Republic of Yugoslavia. The view of Crisis Group was that the denial by Belgrade of Kosovo Albanians' political, economic, social, and cultural rights meant that they had a right to seek self-determination externally. Since then, Crisis Group has published 46 reports on Kosovo. Our most recent one, which was published last month in August 2010, included a quite controversial recommendation that international actors should not prevent Kosovars and Serbs negotiating together on issues that could include land swaps, if their talks would help them put a final resolution to this conflict and would lead to a recognition of Kosovo's independence by Serbia. But our position on Kosovo's independence has remained the same throughout, which is that we support Kosovo's right to secede and to be recognized by the international community as an independent state. A few months ago, in fact in May 2010, we published a report on war crimes in Sri Lanka, in which we detailed very severe violations of international humanitarian law, both by the Sri Lankan government forces and by the Tamil Tigers, particularly during the last 4 or 5 months of that terrible war which they had waged for a period of over 30 years. The evidence that our investigators gathered suggested that in these last few months of the war, tens of thousands of Tamil civilians, men, women, children, were killed. Many were wounded. They were deliberate attacks. We suggest credible evidence to suggest that they were deliberate attacks on civilian targets, on hospitals, intentional shelling of civilians by the Sri Lankan forces, and that there's evidence to suggest that through the chain of command, this would implicate the responsibility of top government and military leaders. We called for an international investigation into these alleged war crimes in Sri Lanka, and we felt that this had to be an international investigation given the demonstrated lack of political will or capacity for genuine, credible domestic investigations inside the country. And yet, despite the increasingly authoritarian regime in Sri Lanka and its still appalling treatment of the Tamil minority, Crisis Group believes that the best means of ensuring the Tamils' right to self-determination is still within the existing borders of the Sri Lankan state. And we've actually published also a report on the diaspora, the Tamil diaspora, urging Tamil leaders outside Sri Lanka to not only to renounce explicitly the Tamil Tiger, the LTTE methodology, but also to renounce its separatist ideology if it's to play a useful role in opening a political space for the accommodation of the Tamils' right to self-determination inside the existing state of Sri Lanka. In Sudan, the South Self-Determination referendum, which as you know is scheduled for early 2011, if genuine, we are persuaded, like most observers, will actually produce a very strong vote for secession from the North. The Comprehensive Peace Agreement, which was signed in 2005 between North and South, ending, of course, 20 years of very brutal warfare, provides for that referendum, and it envisaged that the Khartoum government should, during that 5-year period between then and now, should have implemented reforms to make unity attractive. That's the language of the CPA. But that failing that, a referendum would have to be accepted as the method for determining the future of the South. Now, as we know, very little progress has been made in this project of making unity attractive. I think it's fair to say that the conflict in Darfur provided a pretty catastrophic distraction from the North-South project. and that we, of course, have been supporting the implementation of the Comprehensive Peace Agreement, and the goals of unity having failed, we have urged the international community to support the referendum process and to accompany, if that's the result, the creation of a new state of South Sudan in Africa. Now, these conflicts, Kosovo, Sri Lanka, Sudan, are only 3 of approximately 60 conflicts that International Crisis Group covers and reports on. We publish approximately 80 to 85 reports per year covering conflict situations all over the world. We put all our work product on our website. We work from the ground up. We are not driven by any particular national interest or ideology. And then we take these reports, which are prescriptive for the most part, not only descriptive, and we engage directly at the highest possible levels with leaders in Washington, in New York, in Brussels, and increasingly in emerging centers of important decision-making, particularly in the Global South, in order to promote the peaceful resolution of conflict and, if at all possible, the actual prevention of flare-up of armed conflict. It's pretty clear in these 3 cases, Kosovo, Sri Lanka, and Sudan, that there is a potential and actual source of deadly confrontation linked to a theme that is very current in our reporting, which is the clash between the principle of territorial integrity and the right to self-determination. A clash, of course, that takes place at the confluence of law, politics, power, economics, and search for identity. Crisis Group has dealt with a variety of situations in the last several years where conflict, including armed conflict, was triggered, either by the purported exercise of the right to self-determination or by efforts to resist it. In many cases, secession claims, as you know, are rooted in a history of repression, exclusionary visions of governance, or the denial of rights of minority groups, which drives these groups to pursue self-determination outside the confines of state borders. And I've mentioned the 3, but I could just as easily have included Somaliland and Montenegro, where we have supported independence, northern Iraq, where we have defended the unity and territorial integrity of Iraq, or Abkhazia, South Ossetia, Nagorno-Karabakh, Aceh, or Kashmir, where we have avoided taking an explicit position either for or against secession, but all cases where secessionist movements and claims continue to be advanced. We believe in Crisis Group that every conflict situation is different and our work is profoundly contextual. That's why we feel very committed to working directly from the field. So our analysis is first and foremost contextual. But having said that, especially when we see this landscape of self-determination claims, I think it is useful to explore the contours of this right to self-determination in order to ensure that the prescriptions we offer for conflict prevention are well anchored in law as well as in political reality. So let me turn briefly to the legal framework. The thrust of my argument starts from the basis that neither the right to self-determination nor the principle of territorial integrity can a priori trump each other. There's no dominance of one principle over the other. It's only by understanding when and how the right to self-determination properly applies that we can effectively put in place processes which will stand some chance of averting or rapidly ending secessionist-based conflict. So the legal framework. In that regard, the recent opinion of the International Court of Justice on the legality of Kosovo's unilateral declaration of independence provides a useful but certainly not a dispositive backdrop. As you know, on the 22nd of July 2010, the court rendered its non-binding opinion on the question that was posed to the court by the General Assembly, and the question was as follows: is the unilateral declaration of independence by the provisional institutions of self-government in Kosovo in accordance with international law? Now, I don't propose to engage in a detailed analysis of the opinion, But I think it's critical to observe that the court was very careful to articulate the narrow scope of its opinion. It concluded that there was no rule of international law prohibiting that declaration of independence, and that in the circumstances, the Kosovo's unilateral declaration was not in violation of international law. The court, however, went no further. It explicitly refrained from ruling on the legality of secession itself. It ruled solely on the legality of the unilateral declaration. It sounds like a very subtle point, but it's absolutely, I think, critical. As such, it did not address the efficacy of Kosovo's unilateral declaration of independence or of the level of international recognition that it attracted in actually creating an independent, sovereign Kosovo state. The ICJ's opinion in that case may or may not lead to a wave of additional recognition for Kosovo's independence. These will be political reaction to the court's opinion. As the court points out, some unilateral declarations of independence in the past have been specifically repudiated by the international community. It mentioned Southern Rhodesia in 1965, Northern Cyprus in 1983, and of course, Republika Srpska in Bosnia in 1992. So having surveyed these cases, the court found that there was no international law principle as such prohibiting unilateral declarations of independence, since in the cases of repudiation, this was again very contextual and based on the fact that in Southern Rhodesia, Republika Srpska, or Northern Cyprus, there was the reality or the expectation that these secessionist movements would be accompanied by the unlawful use of force or other egregious violations of norms of international law, which was not necessarily the case elsewhere. So while secessionists elsewhere would be wise to take limited comfort from the court's opinion in the Kosovo case, equally with those authority who currently assert the sanctity of their existing borders as an absolute bar to any secessionist demands, would be very wise, again, not to take any comfort from the court's opinion. The ICJ's Kosovo opinion leaves unanswered the important legal question of whether a right to secession can be found in the right to self-determination, and if so, in what circumstances. So I think for that we need to examine the right to self-determination itself. As you know, this is a right that is expressed in Article 1 of the United Nations Charter, and also in Article 1 of the two most important international human rights instruments, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. And let me just state exactly how that right is expressed. It says in all these documents, and I quote, "All peoples have the right to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development." Now, even though it's formulated not as an individual right, but as, quote, "the right of a people," it does belong to the body of international law that concerns itself directly with individual rights, even though it's said as the rights of peoples, rather than rights of states, and it is considered a general principle of international law. Now, I'd like to turn to the third paragraph in the preamble of the Universal Declaration of Human Rights, which in my view has tremendous significance in the context of the right to self-determination and to the peaceful resolution of conflicts. This paragraph in the preamble reads as follows: "Whereas it is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights be protected by the rule of law." Now, since self-determination is a fundamental human right, I suggest that it should be protected by the rule of law if man is not to turn, as the preamble states, as a last resort to rebellion against tyranny and oppression. Now, it's unclear whether this recourse to rebellion is meant merely as a description of a potential reality, or whether it contains an acceptance that in the face of tyranny and oppression, rebellion would be not only inevitable, but actually justifiable. But on its face, the right of peoples to freely determine their political status, unfortunately, does not address specifically how and when this right is to be exercised. Whether the right to self-determination includes an entitlement to full state sovereignty, therefore requires the examination of another principle, which is the principle of territorial integrity of states. That principle, as you know, is often advanced to block any secessionist claim. The International Court of Justice, in its consideration of the Kosovo case, made an important observation, namely, that the scope of the principle of territorial integrity is confined to the sphere of relationships between states. By contrast, the right to self-determination deals with relations between states and peoples. It's an important distinction, and I think it invites us to consider that when these principles appear to clash, they should be interpreted in a way that maximizes the fullest effect of both. And I suggest that we must seek to reconcile these apparently competing principles. And international law has, in fact, developed a framework to try to give the fullest effect to both these principles. And the way it has done so is by asserting that self-determination is a right that must be initially fulfilled internally, that is, within the boundaries of existing states. This imposes on sovereign states serious obligations regarding both democracy, that is, participation, as the preferred method for a people to freely determine its political status, and, of course, the protection of minority rights to ensure the fullest protection to the free pursuit of people's economic, social, and cultural development. So in that way, international law will protect territorial integrity of a state as long as that state's government represents all the people or peoples on its territory without discrimination and in full respect of their right to pursue their own self-fulfillment, as this right is guaranteed, which includes, of course, the protection of language rights, freedom of religion, freedom of speech and assembly, and so on. But when a state proves unwilling or unable to provide for this internal fulfillment of the right to self-determination, that right may become an external right. And at that point, it may override the principle of territorial integrity by providing to, quote, a people a right to secede from the parent state. Now, this has been recognized in very narrow circumstances, but particularly in cases of people under colonial rule or under foreign occupation, although in that sense, one might argue that it's their own territorial integrity that would be restored. But arguably, and this is not finally decided, and certainly not in the Kosovo case, the same could be said of cases of subjugation, domination, or exploitation of a people by its parent state, where the denial of the right to self-determination is so profound that the external right is then triggered. In the Kosovo case, the court referred to claims that the population of Kosovo had the right to an independent state because of that province's recent history, and that's referred to as remedial secession, but the court explicitly refused to deal with that issue on the basis that it was beyond the scope of the question that was put to it. And that's why I say nobody should take too much comfort from the decision of the court, because it really doesn't deal with this issue. The Supreme Court of Canada, in the Quebec secession reference in 1996, addressed that question and again did not decide the point, merely noting that a right to secession could possibly arise, and I quote, where a people is denied the meaningful exercise of its right to self-determination within the state of which it forms part. Now, at this stage, I think it's fair to say that in international law, there's clearly no right to secede as such, but that the right to self-determination may permit, in some circumstances, unilateral secession, and in such cases, international recognition by other states completes the process and gives efficacy to the creation of a newly created state. This legal framework, of course, informs, but only partially, the political response to claims of that nature. From a conflict prevention perspective, there can be no absolutist position. Territorial integrity should be maintained, but not by the brutal repression of a people in violation of its right to self-determination. That right requires that there be internal political space for the free pursuit of a people's social, economic, and cultural development. And both international law and political reality will ensure that only the most severe violations of that right, colonialism or its equivalent, will trigger a right to secede, or the external right. I don't want to take very much time, but I'd like to turn now to criteria outside this legal framework, because when secession claims are advanced, I think the first thing we should observe is that they should be addressed by orderly, peaceful processes. We should never advocate the recourse to force, either to advance or to block these rights, and we should instead constantly search for orderly processes. For instance, secession should preferably be effected under domestic law. Some federal constitutions actually provide for mechanisms for, if not their total dissolution, at least parts of secession. Or in the case of Sudan, the Comprehensive Peace Agreement provides for a binding referendum, and that's why it's critical to support that process. Now, in the absence of a prescribed process, however, secession could still be effected consensually with international actors supporting bilateral peaceful initiatives. Now, absent a consensual, negotiated, successful process, however, I suggest that the international community should support a secessionist enterprise when the legal conditions are fulfilled, and as I said, they're very narrow, and when it is otherwise appropriate to do so. So that begs the question of when is it otherwise appropriate to do so? And that's very much the kind of environment with which Crisis Group operates in a contextual fashion. So I'll give you just a string of potential criteria that would maybe inform that decision. The first criteria that is often advanced is the one of last resort. And as I've already discussed, claims of self-determination should ideally be resolved within the framework of existing states. So generally, we would support independence only where there's no hope for the conflict to be resolved or for the right to self-determination to be fully realized within existing borders. And I think the case of Kosovo, for example, especially after the 1999 war, made it clear that it would have been then and still now impossible for the right of Kosovars to be sufficiently accommodated within the framework of Yugoslav or Serbian state. So independence for Kosovo was seen, and I continue to believe, is the only solution that could lead to lasting stability in the region itself. In the case of Somaliland, insistence by the African Union on the increasingly abstract notion of national unity and territorial integrity of the Somali Republic, we believe should not be a bar to the aspiration of the creation of a separate state when unity is simply no longer a feasible or realistic option. The second principle, apart from last resort, is that of popular support. The Kosovo Albanians' overwhelming support for independence was, and I think remains, a key factor here. Questions of secession should be decided democratically, as in Montenegro, for instance, through the referendum in 2005 and the forthcoming referendum in Sudan. Crisis Group often draws attention, which is an important distinction, to the disparity between sometimes very extreme claims of secessionist leaders and the frequently considerably more moderate views of their wider populations, who may be more realistic in their aspirations, and we believe that is the case of the Tamil population inside Sri Lanka, and that we should be wary of much more extreme claims often advanced by diasporas. The Supreme Court of Canada, for instance, insisted that the secession referendum would require, at a minimum, a clear majority answering a clear question. So it's important to consider also, and in my view this is very fundamental, the rights of minorities within the secessionist minority itself and the likelihood that their rights would be adequately protected within the newly separated state. This will be a very important question, I think, in South Sudan after the referendum, where there are ethnic tensions that are currently potentially suppressed by the unity of the secessionist movement, but that will quickly emerge when the state is constituted as an independent state. Secession may provoke population displacement and further unrest if the newly created nation state is unwilling or unable to accommodate its own newly created minorities. It's often advanced also that claims of sovereignty have to be earned. Now, I must say, in general terms, I'm very wary of any notion that fundamental rights need to be earned. In my view, they don't. That's why they are fundamental rights. And yet, there's no question that, for instance, Somaliland's democratic root and functioning institution assist in advancing the legitimacy of its claim to independence. And in the same way, for instance, ahead of Montenegro's referendum in 2005, we had argued that Montenegro was the only republic of the former Yugoslavia that had formed a genuinely multi-ethnic government without internal conflict. So in that sense, it's not that the right has to be earned, but that the realization of the right, I think, has to be compatible with, in particular, the rights of others. Conversely, at the other extreme, the Tamil Tiger's brutal rule of Tamil areas, the brutal rule of the areas that where it controlled its own people, and the atrocities perpetrated over the years by the LTTE, including ethnic cleansing and massacres, and their treatment of the Muslim minority inside their areas undermined very severely their claim, their secessionist claim. A related concern is one of state feasibility. Can a territorial claim easily be asserted within existing or easily defined border? So is there a match between the people and a claim to an easily defined territory, or are they so diffused that it would be virtually impossible to have the geographic creation of a state? There are many other criteria. One that is often advanced is the question of whether there's economic feasibility for the aspiring new state. And I think we need to be very careful here in not setting the bar any higher than we do for existing states. There are currently many developing countries who are extremely economically dependent from foreign assistance, including in some cases for the support of up to 50% of their budgets. So I think when looking, for instance, at the viability of South Sudan, we shouldn't set the bar any higher than we do for existing states. So these are some of the criteria that are often advanced, even when the legal threshold for secessionist movement is met. I think we need also to consider the question of regional dynamics and precedents. Our calls on the African Union to engage positively with questions of separation, I think, has to also defer to their own concern about the beginning of redrawing of borders on that continent. And finally, of course, there's a host of intangible factors that come into play: history, culture, language, religion, emotional, some would say at times totally irrational aspirations, grievances, loyalties. All these will come into the mix of initiatives and responses that will either support or attempt to thwart secessionist projects. Let me conclude by suggesting that international actors would be very wise to remember the warning in the preamble of the International Declaration of Human Rights that people will turn to rebellion against tyranny and oppression unless their fundamental rights are protected by the rule of law. So international actors should make every effort to promote the full respect of the right of peoples to self-determination by national governments. In order to avoid the emergence of legitimate secessionist claims, states must recognize legitimate grievances by their national minorities and must address them appropriately, including by providing some form of political autonomy, if appropriate, but certainly by ensuring political participation as well as social, economic, and cultural protections. Inclusive governance, the best prophylactic against many types of conflict, also provides the best protection against secession claims surfacing, turning violent, and being unresolvable in the first place. But even if they do turn to violence, faced with a total breakdown of the rule of law, the international community cannot blindly support the monopoly over the use of force by governments who have forfeited any legitimate entitlement to such monopoly. And I conclude again by stressing that I don't think we should blindly prefer the principle of territorial integrity over claims of self-determination when there's no basis in law, in politics, or in any form of moral grounding for expressing such preference. Thank you very much for listening to me.
I thank you for giving us an exceptional opportunity to have our own tutorial on self-determination. So I'd like to open the floor to questions, and I just ask that you wait till the microphone comes to you, and please identify yourself.
Ms. Arbor, my question may be a little unfair because it requires a knowledge of American history, which may not be appropriate for a Canadian,
unfair.
but I wonder if you could apply your analysis to the situation in 1861 in this country, where the southern states claimed that they didn't, that their rights of self-determination were being limited by the federal government, and the federal government insisted that the right for territorial integrity trumped the rights of the Southerners.
I can't. I mean, it would be, especially in this audience, it would be hugely presumptuous. I just don't know enough. And I think it's very difficult to look back because things get resolved by a series of factors that acquire over time even their own legitimacy. So this entire analysis is meant to be prospective, very difficult to apply it retroactively, certainly by someone as ignorant as I am of American history.
James Starkman, thank you for a very illuminating discussion. In the case of Kurdistan, or a prospective Kurdistan, it struck me that this might be a fairly unique example where you had two sovereign states, one a dictatorship in Iraq, formerly a dictatorship in Iraq, and a democracy in Turkey with more or less outlined ethnic borders for the Kurds. How is the ICG treating the prospective Kurdistan issue?
Well, we have not addressed this particular issue or the claim for the formation of a separate state. This is complicated, I think, and you've pointed out an issue that would arise very frequently, for instance, in Africa, of self-determination claims that are asserted against more than one state. It's tough enough, difficult enough to figure it out when it's asserted against a parent state. And I think in Africa, that's very much part of the concern, that the colonial boundaries, if we are to embark in the rights of, and we haven't talked about what is a people, what is this core group that asserts the right to self-determination. But if we look at it on ethnic basis, for instance, or other forms of identity allegiance, it becomes much more complicated if it's asserted against two states, or in some cases, it would be even more than that. So we haven't addressed that particular claim. I think it's fair to say that we would also constantly want to promote, as I think we must in international law, the fulfillment of the right within existing border, that is by certainly encouraging existing states to democratize or permit forms of participation, including some forms of autonomy going as far as is necessary to accommodate the self-determination claim within existing borders. But how it then interplays where a group, a people, is currently divided between two states, whether they're both sufficiently democratic to protect their right within their own borders, this kind of lack of unity of the group poses, I think, a slightly different question.
Rita Hauser, Louise, thanks for a wonderful tutorial. You avoided discussing, to my mind, the single biggest failure of the international community in this respect, which is Kashmir, and which is now boiled over into a very violent affair. Originally, a referendum intended, never held. division never occurred. Now there is a demand for independence, at least a part of Kashmir. How do you view it?
Well, Crisis Group has published. We do work in the region. We have published over time in Kashmir. I mentioned that there are many circumstances. Kashmir is one of them. It's not the only one. Abkhazia, South Ossetia, and Georgia. There are many cases in which we haven't taken a position. When I speak to my colleagues in Crisis Group, I mean, the reality is, even though we describe ourselves as a conflict prevention organization, I think it's fair to say our work is equally divided between cases that are clearly conflict prevention, cases in which the reality is we're talking about conflict management, and cases where we see opportunities for conflict resolution. I think in the case of Kashmir, we're still in a conflict management model. Everybody would want to advocate a resolution. In the current political landscape between India and Pakistan, and possibly the lack of appetite for international brokers to step up to the plate and address this issue, since they're somewhat preoccupied elsewhere, including in that region. I think it's what we see currently as realistic is this kind of conflict management, trying to minimize clashes, create an atmosphere for at least a peaceful continuity of the ambivalent status of the region. I think in many cases, we don't see an opportunity, or we see it as premature to take a firm position one way or the other. And I think it's currently exactly our view as well in the two Georgian regions where, now this may lead, that's a danger, to frozen conflicts where 30 years from now, we'll still be talking about looking for options. That's exactly why in the case of Kosovo, we felt that this is the time, while the conflict is still relatively recent, to try to unfreeze it and not turn it into a permanent dispute involving the north of Kosovo. But in the case of Kashmir, I think conflict management is probably the only current realistic option.
I'm John Richardson from New York. I really appreciate, it's an honor to listen to you discuss these things, but I have a general question. The world has known empires where multi-ethnic and multi-religious groups have survived, somehow the Mughal Empire, the Roman Empire, others, lots of them. How much in the world you see, the world you deal with, how much is this driven by religion, or by economics, or by ethnicity? I mean, if you're an ethnic person, but you're economically active and successful, maybe that's okay. But how do you see these different pressures? Take religion. I'll make it easy. Just take religion.
Well, let me just take shelter into the work of my organization by stating at the outset that over its 15 years of existence, Crisis Group has deliberately never done work on this kind of broad thematic basis. We feel there are many others who are able to do so, very well poised, many think tanks in this country. So we have not produced these very big conflict-related thematic analysis, for instance, of what's the relationship between climate change and conflict, or gender and conflict, or the drug trade and conflict, although we've done some work on that. So anything I could give you in response to that question would be largely anecdotal and not particularly well anchored in analysis. I think we're easily distracted currently by the predominance of religious extremism in fueling conflict. This comes and goes, I think, in history, and other factors will come and go and play a part, and I think climate change, for instance, and severe deprivation, particularly of access to food and water, will at times maybe look like the dominant characteristic as a source of conflict. My own sense, for what it's worth, is the root causes of conflict are extremely contextual. They are rooted in particular history, the politics of a region, and so on. But the response, if there is the advocacy of a universal response currently, at the stage of development that we're in the world at large, I would say that the best response to the anticipation of conflict is the building of institutions, of governance institutions. And I think, again, generally speaking, countries that have adequate mechanisms to handle conflictual situations do much, much better than countries in which the institutions are very frail, regardless of what the original trigger is for conflict. I was the prosecutor for the War Crimes Tribunal for the former Yugoslavia and Rwanda. You'd be hard-pressed to think of two models that are more extremely different in their culture, history, and so on, and yet both of them, within the span of a few years, led to terrible, terrible atrocities being perpetrated. And I'm often asked, do you see any commonality, do you see any themes between the two? Well, there are some. I can't tell you whether historians and others who will look with some distance to these two conflicts will see the same themes. I saw a lot of pathologies. First of all, the pathology of identity, right, of the search for belonging, which is normally a very healthy human aspiration. We search for our personal identity and our belonging to the immediate family, the clan. This is how we determine the scope of our language, cultural, religious affiliation, and define ourselves. Both, I think, in the case of Rwanda and the region, right? It was not just Rwanda, Burundi, the Great Lakes, and to some extent, these factors are still there, kinds of pathologies in the search for identity where rather than pursuing the desire to belong, when I say it's a pathology, it's turned into the desire to exclude, and ultimately, in its most extreme form, to genocide, to the actual elimination of the other as a form of affirming identity. In the two cases also, I think there were pathologies of the principle of obedience, loyalties to leaders, fed either by, in the case of the former Yugoslavia, communist ideology, possibly in the case of Rwanda, either by religious colonial teachings that overplayed obedience as a virtue, where people surrendered their own moral judgment. I mean, there are just so many factors. I couldn't begin, I think, to do justice to it, but these were very striking to me in these cases. The surrender of personal moral judgment is, I think, a huge factor in mass slaughter, in following, and in both cases also, extremely bad leadership. This would be putting it mildly.
The gentleman on the balcony.
Thank you, Ms. Arbor. My name is Korch. I'm a New York-based lawyer. I'm originally from Kosovo. It seemed to be the focus and the onus that the right of the self-determination of the people. But there doesn't seem to be much of thinking of the right of a certain government over the people within their borders, to control them, to rule them, or to oppress them. The last UN Secretary General Kofi Annan and the Nobel Peace Nobel Peace Prize winner Archbishop Tutu mentioned that the first duty of the government is to protect its people. If it doesn't do so, then the international community has the right to intervene, and the people have the right to secession. Why there is not so much focus on the government to have a right over the people within a certain borders? And if quickly your analysis of the ICJ opinion was that there is a distinction between legality of declaration of independence and the legality of secession, will not be meaningless if the ICJ declares that there is a legality of declaring independence, but there's illegal to secession. Will they contravene each other? Thank you.
Well, I'm not a big fan of rights of states. I think states are constructs that are governed by law, and certainly in the what we aspire to is states that derive their power from the democratic will of the people. So I find it not particularly useful to contrast rights of states and rights of people. It's certainly, I think, in the framework of international or universal or even national human rights frameworks, people have the right to turn to the state to their protection, and they have a right to participate in the system of governance to which they will then be subjected. And I think it's very dangerous to confuse also rights of states and rights of current government or people who lead. I think they have the onus of earning their entitlement to exercise authority over their fellow citizens. But as such, I don't think they are duty bearers, not right holders, states, that is, in the framework of international human rights law. And as for the distinction in the court's opinion, all I could say is, this is very typical of legal reasoning. The court said, we were asked a narrow question, we will provide a narrow answer. Now, whether there would be cases where the court would say a unilateral declaration of independence is not against international law, but secession itself is not effective, this is very speculative. I suppose it could happen if there was no international recognition, for instance. The secession itself could not become effective, for instance, if the newly created state received no or virtually no international recognition, or only the support, say, of one member state of the United Nations. But this is very speculative, and the court deliberately did not, and probably correctly, answered, especially in a context that is so intensely political, probably wise of a court to say, we've been asked a narrow question, here's the narrow answer. We leave to another day where the question is posed clearly, and the debate is then formulated clearly to answer it.
Susan Gittleson, in light of your brilliant analysis and your great knowledge of what this whole subject is about, what can the international community do to prevent genocide when it appears on the horizon, or to prevent extremist groups or even individuals, suicide bombers, which apparently was started by the Tamils, from disrupting negotiations on a democratic parliamentary level as much as possible, but as, for example, in Iraq, every time a group is against the general decision, another mosque is bombed or whatever. So what can the international community do going forward to prevent violence?
Well, I think in the aftermath, particularly of the atrocities in the former Yugoslavia, in Rwanda, so say in the last 15 years, there have been several responses outside the more classic arsenal of international community response. One of them has been the creation of international criminal justice, using justice as a tool, in a sense, of conflict management, personal criminal responsibility of leaders, political and military leaders, the creation of these two tribunals, the International Court of Justice. It's not the sole response, but it's a novel one that in international law had never been used until about 15 years ago, except for Nuremberg and Tokyo, which had not been duplicated since. It's a modest response. It's one of them. Another one, I think, has been the emerging doctrine of the responsibility to protect, which, again, is really struggling to anchor itself in the body politics of international actors, but is offering a very useful framework. It basically, first of all, asserts, which to me is the obvious in international law, which is that sovereignty, comes back to the previous question, sovereignty is not a shield against scrutiny. State sovereignty is a bundle of responsibilities, and if it's understood that way, then the international community, states talking to each other, are entitled, they have an interest in ensuring that each state exercises its sovereignty in a way that is conducive to peaceful international relations and to the peaceful management of domestic disputes. So, starting from that premise that states have the primary responsibility to protect their people, this doctrine asserts that if a state proves unwilling or unable to protect its own population, particularly against what are called, in general terms, mass atrocities, genocide, war crimes, crimes against humanity, ethnic cleansing, then the international community has a responsibility, not a right. A right is optional. Right? If you have a right to intervene, that was the previous doctrine of the French doctrine of le droit d'ingérence, the right to intervene, the right of humanitarian interference. If you have a right, you have the privilege of declining to exercise it. This new doctrine speaks of a responsibility to protect. If a state is clearly in default, that was the argument, say, in the case of Darfur, of protecting its own population, or worse, is in collusion or responsible for attacks on its own population, the international community has a duty to intervene. And then there's a range of intervention: preventive measures, engagement, encouragement, and ultimately, under the Security Council umbrella, could even include the use of force. This doctrine has been now at least rhetorically accepted within the UN, but when I look at what happened a year ago in Sri Lanka, I'm thinking, well, where is the doctrine? People were being slaughtered on the beaches of Sri Lanka, and the international response was absolutely non-existent. The Security Council, recently on a smaller scale in Kyrgyzstan, you couldn't get the case into the Security Council, and regional organizations, OSCE, European Union, and the network of political organizations very much led by Russia were all totally uninterested in interfering in the internal affairs of Kyrgyzstan, where the Uzbek population in the south was at tremendous risk, including massive displacement and killing. So the framework, the doctrine is there. Its application is very much at the mercy, again, of political calculus.
Mike Sponder, could you give us some successful examples of what you call the independence inside of borders? In other words, when you talked about independence of ethnics, or I'll even use Kosovo, it didn't work, but give some examples where there has been conflict resolution, not the fact that the peoples themselves solved it.
Well, I wish, again, I could bring some of my more knowledgeable colleagues to draw on that. I would say that federalism has been a mechanism of accommodation. When I said one form of response is the granting of some autonomy. And again, if I turn to my own country, I think in the case of Canada, the federal model has permitted, in and of itself it's not sufficient, but it has permitted the accommodation of an ongoing claim by some national peoples, the French-speaking people of Quebec, asserting their desire for more and more and more autonomy, including in some cases for the creation of their own separate state. Now, this peaceful accommodation, I think, is to a large extent a factor of a very, very strong governance institution. The Supreme Court of Canada, which I think was hugely instrumental and very much a model looked upon by other countries in designing a framework for the democratic resolution of these claims, participation through institutions. So I think, for instance, federalism is one. I'm trying to think of other instances in which this had been accommodated. I think different models of electoral systems as well, power sharing. Certainly, I think in many African countries, you'd want to promote that, power sharing.
Was specific countries, not generalities of what to do.
I could give you examples of peaceful conflict resolution, but not specifically on that issue. There's nothing, maybe somebody could think of one that would jump to mind. Northern Ireland, yeah.
Nigeria as well.
Yeah, it's no. Well, yeah, these are still, these claims are still asserted. The question is how they're managed. I think we cannot aspire to the elimination of conflict. In fact, in many circumstances, we thrive on conflict. We promote conflictual activity in sport, for instance. The question is, a crisis group is interested in the prevention of armed conflict. We talk about conflict, it's really the prevention of violence. But clashes of aspirations, of access, I think are so the many examples that have been referred to, others might say, well, they're far from being resolved. Well, they're not resolved But as long as they don't flare up into recourse to violence, that means we have the proper institutions to deal with these conflicting aspirations.
I want to thank you for really sharing your expertise with us. It was an honor to have you with us today. Thank you.